All right. Welcome back to the afternoon session. I'll be very brief. My name is David Simpson. I'm associate professor here at New York Law School. I wanted to just take 5 seconds to thank Penny for including me in these programs, for being a kind mentor, for always allowing us to grow as scholars and bringing us here to celebrate the work of a giant in the field that I am starting to call home. I have the very brief job of briefly introducing the panelists for the panel on what in the past might be a template for the future, mapping how we got here, and what a great group of panelists that we will have. I'll introduce the panelists in the order in which they will speak. We'll start with John Barrett, the Benjamin Cardozo Professor of Law at St. John's University, who teaches constitutional law, criminal procedure, legal history, and whose expertise is on Justice Robert Jackson, FDR, as well as Nuremberg. Certainly looking forward to the comments there. Then we'll go to Dean Rebecca Zitlow, who is the Dean and Distinguished University Professor, and Charles Fornoff Professor of Law and Values at the University of Toledo, where she teaches constitutional law, federal courts, constitutional litigation, and a foremost scholar of the Reconstruction period, 13th and 14th Amendments, as well as constitutional interpretation. Then we'll hear from Mark Graber, Regents Professor at the University of Maryland in Baltimore, one of only 7 Regents Professors in the history of the university system, and who has received various awards. Constitutional Law Schmooze has been mentioned before, bringing scholars together, and of course, the leading scholar on constitutional law and constitutional history. We had an event like this for Professor Graber's book on the Forgotten 14th Amendment just a few months ago. And then last but certainly not least, Professor Samuel Issacharoff, the Reiss Professor of Constitutional Law at NYU, up the street from here, who is an expert in both civil procedure, law and economics, constitutional law, and one of the founders, I would say, of election law, the law of the political process. So I will now shut up. We will hear for about 13 minutes from each speaker, and I'll be sitting over here with just time reminders. Thank you.
Very much, David. Thank you, Penny. We've been friends for many years. Penny was president and dean of Albany Law School, and Robert Jackson, my leading interest was an alumnus of Albany Law School. So our collaboration goes back to that. I thank Jack Balkin, who I met in person for the first time 2 hours ago, but has been an impressive teacher, mentor, generous email pal, casebook author, et cetera, and really an inspiration. It's an honor to be part of this. Looking to the past and being a Robert Jackson person, it occurred to me that there's something that developed during the Jackson time that is very much a part of our time. And I think of it as a piece of constitutional rot in ourselves. And so that is my topic. It is the practice of applauding living justices for their constitutional law decisions. I do write the Jackson list. I have to tell Jack one comment I get somewhat regularly is people say, oh, you do the Jackson list. It's like balkanization, but not as intellectual. Balkanization is one of our shared homes. And I thank you for continuing that, even if it is an unanticipated consequence. I'm glad it's enduring. This book in particular, in the Balkin book case, is my jumping off point because it is from the historical side, a series of powerful essays, rewritings, new takes on what Brown versus Board of Education should have said. And I want you to hold in your mind that distant perspective on Brown and compare it to the standing ovations at the time, which in an awkward way, perhaps, I'm going to criticize. Brown is a Jack specialty. It's one of my areas of research and writing too, so I'm going to mine this a little bit. But this is really where I want to begin. Events like this. This is Justice Scalia at a Federalist Society annual conference. This is a patron saint of the Federalist Society during his living days, and it's perhaps even stronger now that he is gone. And this is a tradition that continues not only with him. This is Justice Alito at the 2022 Federalist Society annual meeting, the first one after Dobbs. We'll come back, but you can imagine the reaction he was getting then. This is Alito approaching the stage. You get another look at it there. This is Justice Gorsuch at a FedSoc annual meeting. This is Justice Kavanaugh at a FedSoc annual meeting. These are rapturous receptions from people who admire the work, applaud the decisions, cherish the presence of these jurists on the Supreme Court. It's not just the Federalist Society. This is RBG at the American Constitution Society in her prime, a rapturous reception. This is Justice Sotomayor at the ACS, also a rapturous reception. I do have to note, as juxtaposition, you won't find photographs like this of two of our current justices. Neither John Roberts nor Elena Kagan accepts invitations from these kinds of celebratory events. They decline to show. And in a sense, my argument is good for them and shame on us for our inviting and applauding. You might have seen this photo in the New York Times last week. This is Richard Lazarus's wall in his office at Harvard Law School. It was a story about his recent study and Adam Liptap's column. But the picture is autographed Supreme Court decisions. And that's also part of what I am commenting on and criticizing a little bit. This is one signed by Justice Stevens, City of Mesquite versus Aladdin's Castle. It seems to be made out to somebody named Roy Stevens, and then it was resold on the autograph market, so maybe this is a distant relative. But, you know, like signing an opinion of the court when you were the justice who wrote it. And this is, I'm sad to report, even David Souter, our 19th century justice, Mr. Virtue by many measures, autographed Supreme Court opinions now and then. And this is Casey. You know, this is not a small thing to autograph in 1992. But it didn't begin with the contemporary era. This is a news story from 1945, an April 1945 dinner feting Justice Hugo Black, who by this time was the second senior associate justice, the first of the Roosevelt appointees. He is being honored by the Southern Conference for Human Welfare as, on behalf of his work at the Supreme Court in the last year, as the Southerner contributing most to national welfare. This dinner at the Statler in Washington, D.C. was a dinner of 900 guests, a big black tie event. Franklin Roosevelt, who would be dead within 10 days, sent a letter praising him. The Toastmaster and the speaker was future Chief Justice Fred Vinson, who at this point was the Director of War Mobilization. This is a standing ovation, high publicity event for Hugo Black doing good as a jurist. This is Hugo Black's colleague, of course, Robert Jackson, who did not attend and join in the applause that night for Hugo Black. Other justices did. Their relationship at this point was quite fraught and went downhill for a period of time. And this is the court that became Brown versus Board of Education, which still has Black seated to Earl Warren's right and has Jackson in the back row between Warren and Black. This is a 9-0 court, 9 years after that celebratory dinner that I'm focusing on. And I want to focus on a little moment, I think never written, buried in archives, that followed on this May 1954 great event in American history. It was an invitation that came from Herbert Bayard Swope, famous journalist, well known to Robert Jackson and an advisor to Jackson on press aspects of Jackson's work at Nuremberg. And Swope invited Jackson to participate in Freedom House honoring the justices for deciding Brown versus Board of Education. This is Swope's letter about 6 weeks after the decision. Freedom House believes the Supreme Court did great by the segregation decision. Accordingly, they're going to be doing a plaque. It'll be at this dinner. Will you come to this dinner in October 1954? Signed, Herbert Bayard Swope. Jackson takes this in, and about 2 weeks later, sends a negative reply. And this is really the heart of my presentation. And I think an argument that I find quite persuasive. Jackson writes, "My dear Herbert, your letter about the unveiling of the plaque troubles me. I think the court has only done its duty and nothing beyond the line of duty, and that it hardly becomes the justices to participate in a memorial to their own work. I will tell you a story." And then Robert Jackson, who as a young lawyer had a deep background in New York State politics, recounts the 1924 New York State Democratic Party convention, at which the nominee for governor of the Democrats was Samuel Seabury, a judge, a reformist judge, an anti-corruption judge. And Jackson is recounting a side conversation he had here with Mr. Sullivan. I got to find the name. I'm sorry, Mr. Murphy, who at that point, Charles Murphy, is the head of Tammany Hall. And now watch who's the voice of virtue here. Murphy asks Jackson, who's a big Seabury supporter, what's great about Seabury? And Jackson says he upheld the workman's comp law. And then Murphy asks, was it right? And Jackson says, of course it was. And Murphy says, can you run a judge for governor on the ground that he made a right decision? In other words, isn't that just circular, redundant? Isn't it just the law that one adjudicates and uses on the bench? What's that as a political credential? Jackson, continuing, says to Swope, every now and then someone wants to honor a judge for some particular decision or philosophy. I think it is quite different than a general approval of the workmanship, as may be indicated by some honors, which are not tied to particular cases. I do not know how the other justices react to this, but for myself, I will have to decline. I do this the more reluctantly because I know the sincerity with which this invitation is proffered. In other words, Brown versus Board of Education, I am one of 9, was a decision of jurists. It's not mine to dine out on. And it communicates something wrong to the audience to let them think it's appropriate to invite me, to plaque me, to fet me for a decision as a judge. The dinner went forward. No justice attended. Ralph Bunche, by this point recipient of the Nobel Peace Prize, was the principal speaker. It was the Freedom House dinner. Ed Murrow was honored. And the plaque indeed was cast and became part of the wall of what was then Freedom House headquarters. And so there they are, in commemoration of a historic decision. Maybe there are other plaques like this. Maybe there aren't, because maybe there aren't other decisions like Brown. But I do think there is something that Jackson put his finger on that is jarring about this celebratory event. It contributes to a culture of judicial appointments being political battles. It contributes to a culture of judicial appointments being wins for our team. It contributes, I think, to an image of justices in the minds of justices that they've done something great for the world in reaching their best lights decision, rather than just deciding the case and then the next case and the next case, even if it happens to be Brown. And thus, a standing ovation is, of course, what Sam Alito gets from FedSoc for Dobbs. That's the mindset. And a standing ovation is what RBG gets from the New York City Bar Association, from the ACS, et cetera, for the VMI decision, et cetera, et cetera. I think the timing is off at the very least. This is the proper timing. This is Ben Shah's painting of the Brown versus Board of Education court. In other words, after the fact, in art, beautiful 20th century New Deal realism, show us the Brown court, of course. Zero in on the part of the bench. There's Clark and Jackson and Frankfurter, who are part of the 9 who reached this decision. But by the time Ben Shah paints this, and it begins to hang in galleries around the world, they are all dead. And that's a proper timing, I think, rather than letting them feel like rock stars in the immediate aftermath of the decision. What Brown versus Board of Education should have said is a brilliant scholarly contribution about a settled piece of work product by people who at this time were all then dead. This is an appropriate kind of person to fet if you want to fet a case in its immediate aftermath. It's a photo of Ishmael Jaffrey that appeared in his recent and belated obituary published in the New York Times. because he was the plaintiff in Wallace versus Jaffrey. He was the brave Alabama dad, not a believer, whose kids came back and reported a school prayer was happening, despite long established constitutional law, and in the 1980s fought and won this case up to the Supreme Court. This is a way to honor a Supreme Court justice. This is the Cardozo Hotel in South Beach, Miami.
I happened to be over in picture. I went into the desk clerk and I said, "Tell me more about the Cardozo Hotel." She said, "It's so exciting. It's on Gloria Estefan Way." Let me tell you. No idea, Cardozo. And that's totally fun.
This is Robert Jackson. I'll finish with him. This is a little bit of an uncomfortable point I'm making because, of course, I'm interested in him. I'm a fan of him. I'm a biographer of him. But I'm interested in him not for this or that decision. He got some right, he got some wrong by my lights. I'm interested in him as a statesman, a role model, a human being, among other things, as a Nuremberg prosecutor. He dined out a lot at Bar Association dinners and teaching and writing and so forth on Nuremberg, because that wasn't adjudication. That was public service in the executive branch. It was a political job. And those are the places where one, I think, more appropriately takes a bow rather than for judging. Thank you.
No, I like to stand too, thanks. All right, thanks. Thank you so much, Penny, for bringing us all together. It's such a wonderful day. Thanks to Jack Balkin for everything he's written. I saw him a month or two ago. I said, well, what am I going to talk about? Because so much of your scholarship has been so influential to me. But you'll see, I found something. There we go. I've got pictures because, and what my talk is about collective memory and constitutional memory. And I think there's no better way to reflect collective memory is by artwork, pictures. And so that's what I've got here. I've got a slideshow of pictures to back up my talk. In 1852, Martin Delany, a free Black doctor, journalist, and activist, wrote an influential treatise on the rights of free Black people, in which he claimed, "We are Americans having a birthright citizenship." 10 years later, during the Civil War, Delany backed his words with action, volunteering for the Union Army and recruiting Black soldiers for a regiment. Delany was appointed a major in a regiment of Black troops, the highest rank of a Black soldier in the war. And after the war, Delany engaged in political advocacy for the citizenship rights of formerly enslaved people and free Black people. Delany's theory of birthright citizenship was shared by thousands of anti-slavery and Black civil rights activists in the antebellum era, including William Yates, who wrote the first treatise on the rights of free Black people in 1838, and yes, Catherine, Frederick Douglass, a fugitive from slavery who became one of the most prominent abolitionist leaders. During the Civil War, Douglass joined with Delany to recruit Black soldiers who fought for the Union and convinced President Lincoln to allow them to serve. Their activism and sacrifices helped influence the Reconstruction Congress to constitutionalize birthright citizenship and protect the rights of citizenship. Yet, with the exception of the occasional mention of Frederick Douglass, these activists have been largely erased from the current debate over birthright citizenship. Today, I will talk about the importance of including their story in this debate. Jack has, as I said before, so influenced how I think about constitutional law and constitutional politics. But my talk today is primarily inspired by his book, Memory and Authority. As a legal historian who's not an originalist, I'm grateful to Jack for pointing out that history is employed in many, if not all, methods of constitutional interpretation, and that constitutional law is not just what courts say it is. Constitutional law is constructed by political actors, elected officials, activists for constitutional change, rights activists, and, I argue, people who made constitutional claims with their bodies and their actions, even if they did not intend to make constitutional or even legal claims, including fugitives from slavery. As Jack points out, actually, I'll leave Frederick up for a little bit more because, of course, he started out as a fugitive from slavery. As Jack points out, conservative originalists rely only on legal materials and occasionally remarks from people in power on the time that the constitutional provision was drafted, such as elected officials. Their methodology leaves out the people who are most responsible for constitutional change. So, for example, the op-ed written by Randy Barnett and Elon Werban argue narrowly defining birthright citizenship, relying on Blackstone and one sentence uttered by the Secretary of State Stephen Bates in the Lincoln administration. An op-ed just a few weeks ago that Barnett wrote supporting Trump's position in the birthright citizenship case, citing only a few members of the Reconstruction Congress, are examples of people who call themselves originalists, completely ignoring the years of activism of fugitives from slavery and free Black activists for a broad reading of birthright citizenship. In my work, I explore the activism of precisely those people, fugitives from slavery, free Black activists, Black and white political activists who support them. Fugitives from slavery and free Black activists played a central role in shaping our constitutional law with their advocacy for birthright citizenship. Like the current controversy, their advocacy was directly related to immigration, and erasing this role from our collective memory can lead to misinterpreting the meaning of those constitutional rights. In the years leading up to the Civil War, fugitives from slavery, or as I like to call them, freedom seekers, put their lives on the line to escape bondage. By transgressing borders between slave states and freedom seekers such as Harriet Tubman transformed the border states into sites of constitutional uncertainty and conflict, and in doing so, made legal claims both explicitly and implicitly, asserting the right to be free of captivity, the right to freedom of movement, and what Hannah Arendt calls the right to have rights, to be recognized not as property, but as a rights-bearing person. And their actions provoke constitutional conflict over issues of federalism, interstate comity, legality of slavery itself, and most relevant for today, citizenship and due process rights of free Black people. Free Black people and their white anti-slavery allies supported freedom seekers by engaging in civil disobedience of their own, joining in the Underground Railroad, helping freedom seekers to escape, engaging in mass demonstrations, protesting the capture of those accused of being fugitives from slavery, and organizing a states' rights movement opposing the Federal Fugitive Slave Act. Ultimately, tension over the freedom seekers was a major catalyst that led to the Civil War, and during the war, freedom seekers accelerated the demise of slavery by crossing Union lines, exercising their rights of citizenship by taking up arms to support the Union cause. And after the war, members of the Reconstruction Congress cited the sacrifices of freedom seekers as they transformed their claims into constitutional law. Free Black activists made citizenship rights central to their advocacy and claimed that they were entitled to birthright citizenship. In vigilance societies and the Underground Railroad, they supported the freedom of movement, a fundamental right of citizenship, and of fugitives from slavery, and they also advocated for their own rights in what historian Kate Mazur calls the first civil rights movement. They also sought recognition from state governments that claimed them as members and recognized their rights. They argued that they were state citizens with a right not to be deprived of civil rights that adhere to citizenship on the basis of race. They argued that they were U.S. citizens as well, asserting the right to belong in the national polity. They emphasized sacrifices that they and their ancestors had made to the country, including fighting in the Revolutionary War, as they advocated for the right to be treated as equal citizens. They formed conventions which issued statements declaring that free Black people were citizens. They opposed racial restrictions on their citizenship rights, including the right to enter into contracts, own property, and testify in court, and the right to travel, which was always endangered. According to historian Christopher Bonner, by claiming rights as citizens, Black people made citizenship more important. To be a citizen meant to belong to the national polity and to be entitled to fundamental rights, and it also meant that they had the right to stay in the country and avoid forced colonization. The colonization movement, popular in the mid-19th century, highlighted the importance of citizenship for free Black people. Supporters of the colonization movement argued that free Black people should be sent back to Africa where they belonged. They argued that they belonged. Free Black activists argued they didn't belong in Africa, but it belonged in the United States as citizens of their country. Their right to belong, to even stay in this country, depended on their being recognized as citizens, and they claimed that right by virtue of their birth in this country. Other activists include anti-slavery constitutionalists, inspired by fugitives from slavery and free Black activists. They also argued that free Black people were citizens entitled to fundamental human rights. They invoked the Privileges and Immunities Clause of Article 4 to advocate for a broad meaning of citizenship rights for free Black people. Some, including Joel Tiffany of Ohio, on your left there, who wrote an influential treatise, claimed that not only free Black people, but also enslaved people were also entitled to citizenship. And all of these activists influenced members of Congress and the founders of the Reconstruction Republican Party, including John Bingham in the middle, right, chief author of Section 1 of the 14th Amendment, and James Ashley on the right, who was the chief activist for the 13th Amendment in Congress. They developed a theory of rights that was rooted in inclusion and belonging. In Dred Scott, Chief Justice Taney articulated their broad view of citizenship rights, but excluded Black people from citizenship based on their race. But after the war, Reconstruction Congress overruled Dred Scott by amending the Constitution. Free Black people and fugitives from slavery continued to use their bodies and their activism to claim citizenship rights during the Civil War. Crossed battle lines, took up arms to support the Union cause. Their sacrifices were essential to the Union victory. During the war, they presented themselves as citizens. They sought enlistment and equal pay. After the war, coalitions of Black activists formed conventions demanding laws to ensure their right to travel, their right to citizenship, and other rights, other citizenship rights. And the Reconstruction Congress responded with the 13th and 14th Amendments, the 1866 Civil Rights Act that established, among other things, birthright citizenship. So fugitives from slavery, free Black activists played a central role in advocating for birthright citizenship, shaping the meaning of birthright citizenship, sacrificed their safety and even their lives for the cause of birthright citizenship. Yet they are largely erased for the debates over the meaning of the Citizenship Clause and completely absent from those arguing from the Trump administration's exclusionary interpretation of the Citizenship Clause. Their advocacy was not just focused on enslaved people, but at a minimum, all Black people in the country, and did extend to children born to people who are illegally in the country, for example, due to the illegal slave trade. So Jack, in his book, he talks about collective memory, and as he acknowledges, there are no battles fiercer in our collective memory than those battles over, there we go, over the meaning of Civil War and Reconstruction. The racist Dunning School of History in the early 20th century framed Reconstruction as Northern vengeance. In a great essay that Michael Kent Curtis wrote, he talks about growing up in the South and how in the mid-20th century, the Southern states launched a massive propaganda campaign teaching children about states' rights and happy slaves, the war between the states, the romanticized view of the antebellum South, what I call the Gone with the Wind School of History. In the 1960s, largely as a result of the civil rights movement, what historians call the second Reconstruction, historians resurrected the Reconstruction era as one properly considered of inclusion and expanding rights. The Black Lives Matter movement confronted history and even began considering reparations for harms caused by slavery and Jim Crow. But we all know what happened after that: the re-election of arguably the most racist president we've ever had, and the emergence of new scholars such as Elon Werman, who are receiving widespread recognition for their work narrowly interpreting the Reconstruction Amendments, work which cites the discredited Dunning School of Historians. When Trump issued his order limiting birthright citizenship, he was acting as what Jack calls a memory entrepreneur, minimizing the meaning of Reconstruction to only protecting slaves and attempting to change our ethos, the collective memory of our country, as welcoming and inclusive to an exclusionary white supremacist nation of the past. So in the final minute that I have, I want to show you a few monuments which are really the best I think, expression of our collective memory. And the first one is this one here, that of President Lincoln bestowing freedom on enslaved people, Black people receiving rights from powerful white people. It's disempowering. It reinforces the makers versus takers rhetoric of Republicans, arguing that the state should not provide benefits for people who are largely, in their mind, people of color. It denies the agency of fugitives from slavery and their allies, and it arguably supports Trump's unilateral assertion of authority. If one president can unilaterally end slavery, why can't another president unilaterally interpret the Constitution? I prefer this monument, the Black Civil War Soldiers Monument in Washington, D.C., representing the freedom seekers who crossed battle lines and fought for the Union cause. And this part's my favorite, depicting a formerly enslaved Black soldier emancipating members of his own family. They were the catalyst for the Emancipation Proclamation, the Union victory, and the Reconstruction measures that followed. And this one, this Civil War Soldier Monument, which is in small towns throughout the northern part of the country. In New England and Ohio, any small town, just go and look, go to the town square, and you will find these statues. And they represent the role that the individual common man played in winning the Civil War. Many soldiers were drafted, and most fought to save the Union and not to end slavery. But a significant number of white soldiers were motivated by the battle against slavery, and after the Emancipation Proclamation, the Union cause was officially an anti-slavery cause. As Jack has observed, understanding the meaning of the constitutional changes that these people wrought, the best source is to look at enslaved people who played the leading role in creating constitutional meaning and altering the nature of our country. Denying their agency creates the danger of undoing the positive changes that they wrought. And so I want to close with this image, this welcoming, inclusive image of our country, welcoming immigrants who could come here, make lives for themselves, and their children would be citizens. Obviously, this is a romanticized view of what happened in the United States. There's no doubt about that. It's not always followed. It's imperfect, but it's always been an aspiration. And this aspiration is consistent with the advocacy of Martin Delany, Frederick Douglass, Black activists for birthright citizenship. That's really close by, so
The two most important constitutional events of the week are easily the Hungarian election and this conference honoring Jack Balkin. Hungary, Hungarian people threw out an autocratic regime. 5 years ago, Jack Balkin predicted the defeat of an autocratic regime. Now, it's a minor thing. He actually predicted the United States, not Hungary. So, in the talk, he's using the tools Jack developed, that Jack has much insight into the events of Hungary and what is being called democratic front sliding around the world. What I once said of Sandy Levinson is equally true of Jack, that we judge scholars not simply by their scholarship, but more important, by the scholarship they make possible. And Jack has made an extraordinary amount of scholarship possible, first directly by mentoring, and people have spoken about that already, by creating opportunities for scholars, balkanization, other forms, but particularly in Jack's case, that'll argue Jack is the greatest tool fashioner in the legal academy at the long turn of the 21st century. If we just look at what we've been talking about today, conceptual tools, First Amendment infrastructure, the politics of memory, ideological drift, shadow constitutions, The cycles of constitutional time, constitutional rot, constitutional redemption, living originalism. These are all tools Jack has fashioned for all of us. Now, a crucial feature of tools is quite frequently new people use them in different ways. So, for example, the telephone. The telephone, original site was designed to facilitate communication among people. Nowadays, we know this is the greatest thing in the world when we don't want to communicate to people who are sitting next to us. But, it's Scott Bell's invention, and he gets full credit. Because what I'd like to do today is look at events around the world through Jack's tools, which admittedly at some time I'm going to modify, but you'll see his influence throughout. So we begin with the cycles of political time, only not simply the United States, but around the world, because just as Jack has pointed to cycles in American democracy, so we know comparative scholars have pointing that democracy also cycles throughout the world. And one of the features is as the world grows more integrated, the cycles begin to converge. So arguably in the 18th century, what we would call a cycle in the United States really is cyclical politics in New York. And it turns out New York has crucial electoral votes. So cyclical politics in New York turn elections in the country. It's really only cyclical politics, say, the turn of the 20th century. Nowadays, when we talk about democratic cycles in the United States, we have to talk about democratic cycles in the world. And so in many ways, Ptolemy is crucial to understanding cycles, because now we have multiple cycles converging, interacting with each other. But we'll begin with where the cycle was at the end of World War II, the latter half of the 20th century, the second wave of democratization. And now there are losers. And the losers have to figure out how to get back on top. And fortunately, a number of Balkin concepts help us. The first is ideological drift. Why does ideological drift matter? Because at some point, the losers realize they cannot fight on the old terrain anymore, that to defeat the winners of politics, you must fight first on the winners' terrain. And that means taking the concepts of the winners and showing they really support you. Jack has done this on free speech. We know throughout the world, autocrats now use elections and constitutional reform as their means for taking power. Democracy, you can know, it used to be you could criticize democracy. Now you can say, I have an illiberal democracy, but you in some sense must have democratic credentials. My favorite, and this is, I believe, the leading student of critical race theory in the country, is J.D. Vance. Listen to your local chair of diversity. Listen to J.D. Vance. J.D. Vance makes every move they make, only J.D. Vance says it's middle-class white kids who are the real victims of our society. You might think in some ways of Lisa Faust's overture, where a theme is Mephistopheles cannot develop his own melodies. All he can do is pervert it, versions of other people's melodies. Well, this is ideological drift. But of course, ideological drift doesn't stand alone. You need to embed it in a constitution, or what Jack has called shadow constitutions. This is the constitution that will be when you gain power. It is the constitution where you have captured democracy, free speech, equality. But notice something interesting about this Constitution. It is not your originalism of 50 years ago, because now your originalism has to accept Brown versus Board of Education, has to accept a set of free speech decisions, has to accept voting is a right. So while Jack talks about living originalism as a condition of modernity, and I think he's right on that, it's also a condition of politics. All political movements need to tell a story about history. This is memory. It's a story about history that justifies their being on top. I like to say the difference between history, political science, and law is history is one thing after another. In political science, we try to explain everything. In law, they are inspired by a funny thing happened on the way to the forum, must have a moral. But it means as the fixed points, the things you cannot question, change, originalism has to change. Brown has to be justified by originalism. At one point, you didn't like Franklin Delano Roosevelt, separation of powers. Now, originalism must justify a unitary executive. The living originalism is also the way that political movements adjust to things they didn't like becoming fixed premises or fixed stars, as Robert Jackson would say in the universe. Well, what happens to the incumbent coalition? Here, we see constitutional rot. The democratization wave loses steam for a number of reasons. One, as the old autocrats mask themselves as Democrats, it becomes harder and harder for people to figure out who's a Democrat and who is not. As the movement achieves its goals, some people naturally drop out. We've gone far enough. Brown was far enough. Affirmative action is a bridge too far. But I want to suggest another feature of constitutional rot. In some ways, that will answer some of David's questions about causal mechanisms. The original movement, of course, they're never going to take power. They do. But as it takes power, the movement is dominated by movement activists. Not completely. There are always politicians. You can't deal without them. But there is a movement, and there are strong people who are in politics for the sake of the movement. As the movement grows older, the movement politics recedes. Movement activists are replaced by professional politicians who happen to agree on the goals, but for them, things like retaining office and the perks of office are far more important. The elitist wing of the movement tends to predominate. You get a Democratic Party that when they want to hold a meeting, it consists entirely of the funders and the political consultants. The movements are no longer a part, with the result of the gradual loss of the base over time. So I want to say it's not simply the weakening of democracy. It is in some sense, constitutional rot is the replacement of movement activists with professional politicians, which weakens the capacity of the movement to achieve its original goals. It gets its focus, I like to say, of the Democratic Party, its primary focus is on people like us, our rights, our complaints about the world, and a loss of what used to be the mass base of the Democratic Party. Now, where I want to break from Jack is Jack regarded the constitutional rot as a transition period between one regime and another. I don't think Chuck Schumer, who I regard as Mr. Constitutional Rot, regards himself as a transitional figure. He regards the system of the Democratic Party as devoted to the interest of the big donors, the political movements, as natural, and in fact maintained a system for a great many years with Republicans. Viktor Orban is not a transitional figure. what we have here is a regime. And Donald Trump, I'll argue, was not constitutional rot because Donald Trump demonstrated that he could achieve rotten gold. I mean, there are a lot of criticisms of Donald Trump, but one is he's achieved far, one is not, I'm sorry, he's achieved far less in his first year than other presidents. He's achieved far more. Orban. So what has happened? Now here's where Jack comes in. What Orban and Trump did was restart the cycle. It's hard to backlash against generalized rot. But what we saw in Hungary is a restarting of the cycle by a new coalition. Hungarians did new things. They went to rural districts they had never gone before to throw out Orban. What we're seeing in the United States is exactly what Jack told us. We're not seeing Chuck Schumer overthrowing the regime. We're seeing these spontaneous movements in Minnesota and other cities trying to unite. What will replace Trump, if something replaces Trump, is a new movement, and there'll be backlash to that movement, starting a new cycle, and someone else will explain that cycle. They may use different words, but they will use it in the tools that Jack has fashioned for all of us. Thank you very much.
Thank you. It's a pleasure to be here, feting Jack. I apologize that I was not here earlier and that some of my comments may overlap with some of the themes earlier today. I had another conference this morning and so I was unable to attend. So I began teaching full-time 37 years ago at the University of Texas. The University of Texas hired 4 people that year. One of them was me. And then there was this guy I'd never met in the office next door, and that was Jack, long time ago. And Jack at the time was teaching torts and was becoming one aspect of what brought him great fame and success in the legal academy, that is a master of the tools of interpretation. And perhaps that's not the way he would frame it, but certainly early pieces like the footnote were just kind of a challenge to conventional understandings of legal forms of argument, and that has persisted throughout. Part of what I did for today was to go back and look at some pieces of Jack's on matters that are very close to what I am concerned about right now. And that is his writings on constitutional crisis and then constitutional rot. And this includes work that he did with Sandy Levinson. It includes work in a volume in which we both appear that Sandy edited. I want to pick up on this idea of constitutional crisis and constitutional rot, but I want to push in a different direction than what Mark did. So I think that the term constitutional crisis is used in a sloppy way. It's a way of indicating things are bad in a way I really dislike, and so I'm going to put a big time label on it without a great deal of precision. And one of the interesting things in reading Jack's writings over a number of years on this issue is how much more precision he has added to the concept of the general process of backsliding that we're all much aware of. And particularly as he'd start to define constitutional rot more specifically and to talk about the United States as, and other democratic countries as experiencing constitutional rot, not constitutional crisis, it's interesting to see what are the features that he focuses on, because many of the indicators, constitutional rot that Jack identifies, are matters of institutional integrity of the polity. And so what I want to ask is, what is gained by calling it constitutional? And I want to take up this concept that what we are dealing with around the democratic world is a problem of the Constitution's implementation, as opposed to a defeat of the way democracy has been practiced for the period I call the 200 years of democratic ascendancy. That is from 1800 to the end of the 20th century, and then into the period of democratic decline that has characterized the 21st century. So how do autocrats govern? It's a fascinating question that if you go back to the first populist surge in Latin America in the 1990s and then into the European practices in the 21st century, initially, they focus a lot of attention on constitutional reform. And sometimes that's necessary. For example, in Latin America, it's the almost uniform practice that there's a one-term limit on head of state. And so in order to hold power for longer periods of time, it's necessary to amend the Constitution as a formal matter. But we have examples such as Poland and Hungary, where very similar types of illiberal reforms were implemented, one by a regime that had a sufficient supermajority to amend the Constitution, and one by a regime that did not. If you look at the history of Venezuela, Chavez spent a lot of political capital on reforming the Constitution in the early days of his hold on power, and then almost none thereafter. And one of the things that Chavez discovered is that constitutional reform is a highly salient act. And it mobilizes the population. It forces engagement of other actors, including the apex court of that country. Whereas most of the things he wanted to accomplish could be done through what Kim Shepley defines as autocratic legalism. This is the idea that there is ample power in the ordinary functioning of governments under democracy to do just about every bad thing you want to do. And that the only thing that keeps that from happening is a combination of institutional form and norms of behavior and governance. And what I think that Jack is describing as constitutional rot is actually a constant feature of populist governance in our era, which is the undermining of institutions and accordingly the diminution of the importance of forms of restraint. So in the United States, we've never had a prohibition as such on the president overseeing who should be prosecuted and who should not be prosecuted. It's just that wasn't done. And we institutionalized that in a lot of executive orders and things of that sort, but there's no constitutional prohibition on it. And it was the norm that they didn't do things. And then Trump comes in, busts the norm and says, you know, my AG has got to be the person who can best go after the people I want to go after. And if the AG or some local prosecutor can't do that successfully, then fine, we'll get rid of them. And it's not that this is a new constitutional order. It's a constitutional order shorn of institutional arrangements. And the consequence of over-focus on constitutions is what I want to turn to now. But first, I want to cast some blame. And some of the blame for the way we've handled this as academics is on people like myself and Sandy and Jack and Mark, people who come to this from constitutional law, that public law is dominated by constitutional thinking. And so when we go abroad and start looking at it, we look at it through the prism of constitutionalism. So we've seen that there is an overfocus on constitutional processes. And let me give you an example. In Chile, there is basically a breakdown of the political process. There's polarization. The parties are evenly matched. The parliament is dysfunctional. The Senate is dysfunctional. And as a result, everybody engages in this practice of constitutional fantasy. So you take ordinary politics and you move it to the constitutional plane, and you play into the existential crisis mentality of the populace, because now it's one shot, take it all. And what you saw in Chile was the substitution of democratic politics by constitutionalism. And you saw the left capture the first constitutional convention and put out a document which was everything they wanted and got voted down by the population. And then the second constitutional conference, whatever you want to call it, came about, convention, and there they relied on experts, but they had an oversight panel. The oversight panel was captured by the right. So they put anti-abortion into it. They put all sorts of things into it that could never pass a popular referendum. And that failed also. And this became a way of getting around the fundamental problem of our time, which is captured by this constitutional rot idea, but I think it misdirects it. And the problem is that you then think the cure is constitutional reform, and that's the critical issue. So take Peru as an example. 10 presidents in 10 years. It is as close as we have in Latin America right now to a failed state. The only functioning institution is the National Federal Reserve, and every other institution has failed. What's the solution? If you read political commentary in Peru, what do they need? A new constitutional convention, of course, because that will solve everything. And I have other points, but I think that the key thing that we're learning is that ordinary law must function through a set of institutional arrangements. It's hard to say we didn't know this, but we have to kind of bring it to the forefront because if you look at Hungary starting a couple of days ago, and you look at the difficulties that Poland has had, you say it is not their constitutional order that's at issue. It's the collapse of institutional arrangements that can get things done. So the big crisis of Poland was the failure of the democratic government to be able to deliver on basically anything. And what's going to be the challenge in Hungary is, in a country with deeply compromised institutions, from the banking sector to the media to the educational system, how do you restore popular trust in the ability of institutions to deliver critical public goods and also to accommodate the divided views of a population that some of whom will win and some of whom will lose in every subsequent election. And rereading Jack's stuff just reinforced this sense for me that we're too focused on the constitutions because that's the low-hanging fruit. You can read the Constitution. If it's the kind of country that lends itself to it, you can read judicial opinions. And again, I'm being self-critical because that's what I did. That's how I got into this field. I read the Constitution, I read the judicial opinions, but you don't appreciate how these institutions work. And the autocrats were better at that than the democratic opposition. And unfortunately, the challenge of the post-Orban period, the post-peace period in Poland, the challenge has to be to restore the functionality of these institutions, which is not dictated by Constitution text or constitutional reform, but mostly by what Gladstone called the goodwill of the people who have to make the system work. That's a hard challenge. I'm starting to despair of calling it constitutional in any sense but the small c actual definition of the word to constitute. Thank you.
Yeah.
Could I use chair privilege or whatever it's called to just ask a question which came to my mind?
Actually, when Ruti gave a talk at our faculty colloquium a couple of weeks ago, when we think about history and models for the past, what should we be looking for? I guess there's a couple of ways in which you could look for it. One would be you look for heroes, you look for idols, you look for models, and maybe if that's the approach to history, the question is, who are the right people to look for? Is it the judges? Is it other people? Or should we be looking for complicated dynamics that are harder to sort of put together into an easy to understand story, but maybe help us see the complexity in the past a little bit more than a hero story, which is always going to be oversimplified. So when you think about, and maybe what Jack's work, so it helps us think about this too, when we look to, if everybody looks to history, how should we be mobilizing around history? Should it be more a hero story, or should it be more sort of everybody has ups and downs and we should sort of live with the complexity? Is that even a realistic ask in what we're thinking about here? Will be one question.
Yeah, I love that question. Thank you so much. Sort of segues off of my comment to the earlier panel. I think what I look at is the history of resistance to federal tyranny from the anti-slavery movement that I was just talking about. The decentralized grassroots, vigilance societies, et cetera. And I think that helps to, and I think the most helpful way to look at that is as a blueprint, as a model for something that works pretty well. And we can see, others have written about, I've written about this, but others have as well, in the sanctuary cities, the resistance to the federal immigration enforcement is it's just so similar in a lot of ways to the resistance to the Federal Fugitive Slave Act in the years leading up to the Civil War. The same thing with the resistance in Minnesota that we just saw, very similar to the groups of people coming together to stop the federal marshals from arresting people who are accused of being fugitives from slavery in the same kind of cities, in Detroit and Chicago and in New York City in the antebellum era. So that's what I was suggesting earlier. When I think about federalism and decentralized resistance, I think that we can learn a lot from that.
Well, the question first is why are we doing history? And one reason is to try to figure out why the Etruscans disappeared. And it may turn out that's very interesting information, belongs in the museum, but doesn't help. And one should note here, contra to Professor Zeilo, that most historians, it's no longer quite the consensus view, it's probably still the dominant view. You look to history as a distant country. You don't think the resistance to the fugitive slaves was the resistance to contemporary ICE activity. So to give an interesting example of what you might not learn and what you will learn, if you look at the election of 1860, it has a lot in common with the election of 2024 in that rural Midwestern counties went overwhelmingly Republican. That's where the Lincoln vote was. That's where the Trump vote was. But I would submit if you try an Abraham Lincoln strategy, you're probably going to fail, but you might learn something. Why is it the strongest Lincoln counties become the strongest Trump counties. That may help you in formulating a new strategy, but you probably shouldn't go around saying what you're going to do in 2028 is rid the country of the two methods of barbarism, slavery, and polygamy.
I'm skeptical of heroes. What's the saying? Show me a hero, I'll show you a tragedy. People make choices, and they're small choices, and they accumulate. And very few people are making great choices and candidates for sainthood. Most of us stumble, but hopefully with time and experience and education are armed to make better choices. And so I think history, the distant country, I don't know about the Etruscans, but maybe Lincoln, maybe Robert Jackson, maybe the Brown Court, is filled with human beings who are relatable enough, proximate enough, and making choices that are analogous enough that they can cause us to audit ourselves a little bit better, and then maybe lift our own choice making. That's my modest perspective on it. I mean, I'm not here to question Mark, but you read a lot of 19th century newspapers. And what value does that have to you?
Well, I think Sam is.
Sam, sorry.
Yeah.
I'll come up with an answer to that or the question, however irrelevant. That's one of the things I do. How to put in irrelevant answers to questions.
Okay. Frank Munger, this is such a great panel. I really enjoyed all the, and so many profound questions. So I have just a very, sorry. Oh, I'm sorry. No. I give the question. All right. So John, this is a question for you. I've been following your list for a long time, and I'm an admirer of Justice Jackson. But I have a question. You showed pictures of justices who were being politically compromised by being celebrated in these various forums. But you omitted Felix Frankfurter. Now, he was not, of course, celebrated by the Federalist Society or the American Constitutional Society, but he was very politically involved at the time. And so are other justices that we could name. Justices are politically involved creatures. We still admire many of them. Where's the limit on political involvement by justices?
I'm not sure I have a. Oh, I'm sorry. 3 questions. I'm sorry.
It's Christian. We have three.
Got it. Three.
Jewish
Good.
is 4.
Perfect.
Thank you. Thanks.
Thank you. A question for Sam. I think you're absolutely right that the restoration and functionality of institutions is key. On the other hand, it's the constitutions that actually set the rules and the creation of those institutions. And so how does one manage between the relationship of setting up and trying to maintain those institutions at the same time as reinvigorating them?
Yeah, all these presentations are fascinating, and I'll just focus really on a concurrence and a dissent with Sam, that I think there's a lot of truth in what you said about the overemphasis on constitutional design, and I speak as one who's made that argument. But hard. I mean, when we think of the Constitution, part of it is structural design, and I will stick to the argument that we have an unusually bad set of structures. And one of the long-term kind of conversations, we've had more informally than not is the title of your really seminal case book, The Law of Democracy. And my argument has always been that it's the law of the American election system, which has an uneasy relationship to democracy, but it's about because of the institutional structures. So I stick to that. But we then have to decide, well, how complex should a constitution be? And I must say, I'm rather taken by Martin Laughlin's book from last year, Against Constitutionalism, where the ism is what's key. And so he argues, I mean, he's a Brit. He argues for a very, very minimalist constitution that sets up a group of structures that then allow a flourishing politics. And one way of hearing your comments, this is the concurrence, is that we think of loading up a constitution, this is Chile, with not simply a set of structures that we hope would allow some kind of political process to flourish, but to load it up with our favorite rights and prohibiting our favorite wrongs. And that, I increasingly believe, is highly problematic. But so I don't know how much, I don't think you're really complacent about our good old Constitution and we should just ignore the Senate or ignore this, that, and the other. But it does seem to me that, there is something to do with regard to constitutional reform, even if not to go the route that I think you're legitimately discussing. One quick point about Robert Jackson, because I do share the admiration. I think his seal seizure opinion is the greatest opinion in our history, not because of a completely useless three-part test, but because, as I've written on other occasions, he's an adult really talking to other adults about what law means in a realist world. That's why it's a lone opinion. Nobody else signs it because nobody else was at Nuremberg. Nobody else was Franklin Roosevelt's Solicitor General and then Attorney General. And I think one of the things that Sam is justifiably criticizing is that we're desperate to view the Supreme Court as supplying doctrinal tests rather than adult conversations about what should we do in this very complicated world where legal formalism really doesn't work very well.
I can start. And I can take up Heinz's and Sandy's comments together. I was in Venezuela in 2006 at the time of the second Chavez election, the only one where there may have been a question of fraud at the margins that might have tipped the election. And I was interviewed a lot, and the question was always, should the opposition boycott? And I kept saying no. At some point, you have to, but understand that elections are a galvanizing moment, and elections is how the regime claims its legitimacy. And so you have to be in the political dialogue. You have to be in the political process. This carries forward, and I recently wrote something, I don't think it's out yet, but on what about autocratic elections? What about not just autocratic elections where they're flawed, but mostly real, as we saw in Hungary, but nonsense elections under truly repressive regimes? And my view has come to the point where I said, participate until they're rounding up your people and shooting them, because this is the moment that that the legitimacy of the regime for a moment is put in the hands of the people. And it doesn't matter the constitutional design. It doesn't matter how much oppression there is. Of course, it matters in one sense, but this is the moment that happens. And this writing has forced me to go back and reread with tremendous admiration Ernst Frankel's book on the dual state. And when you read that, you have to keep in mind, this is written in 1941. So this is before Auschwitz, this is before the massive crimes. And this distinction between normative and prerogative powers all these regimes have to record births. They have to allow for dissolution of a family. They have to figure out who's right and wrong in a traffic accident. And all these sorts of things are a source of important stability to the regime, no matter the constitutional design. And what autocrats are trying to do is they are increasing the amount of prerogative power they try to have. That's what and taking it away from institutional buffers. So two things happen. They have to have this normative component of ordinary law. And it turns out, and this is why Hungary is such a welcome development, the most important moment of normative power is elections, because these guys, they're not the head of the military. They're not the head of the religion. They're not hereditary monarchs. The only ultimate claim to authority they have is we are the oracles of the people, and the people have spoken. So I view this as the primacy of politics and political institutions, and they have to allow some space for that. Otherwise, they can't get the benefit of the election victory if they get the election victory. And sometimes they miscalculate and they lose. So all of this is a way of saying, constitutions are important. And of course, I'm at a conference, I'm an academic, so I'm going to overstate my position just to get a rise out of people. But let's not overdo it, because what's really important is the ability to organize through institutional mechanisms that protect you. And the oddest ones can protect you. The church in Mexico brought down the PRI through a series of institutional arrangements. The monarchy in Spain protected the transition to democracy. The military in Turkey, on occasion, has protected the democratic. So you don't know where it's coming from. It's not something you would design. First, let's appoint a king. Second, let's establish a religion. Third, let's have a military that has led many coups against us. That's the model for democratic stability. No, that would obviously be lunacy. But it does point to the primacy of politics and people and institutions. And I think as constitutional lawyers, it's too easy to get into our own internal dialogue. This process of democratic backsliding has taken place in every democratic country around the world, regardless of which constitution it has, regardless whether it's parliamentary or first past the post, et cetera, et cetera. I've spoken too
long. Frank's question was about Felix Frankfurter and political compromise. And he certainly was very political, and by our standards, his political involvements, sort of private political involvements, were unethical. Separation of powers issues about advising a president, as Frankfurter did. But going to Sandy's comment about adulthood, so many of the people of that generation were statesmen, were adults in the sense that they were participating in political life at the top level, where their concerns were governing, were national place, were stability in a complicated world. And some of their jobs at a moment involved a judicial robe and deciding cases and working at the Supreme Court. But this is my quick list of people who were serious, actual presidential prospects, and not just in their own minds. Hughes, Owen Roberts, Hugo Black, William O. Douglas, Robert Jackson, Fred Vinson, Earl Warren. Those are adults. And yes, their careers were in a judicial silo for much of the time, but their approach to the issues that they were thinking about in cases were broader than that, were life perspectives that they brought to it. And that doesn't bother me. I think that's fine. I just am saying we shouldn't applaud them for this or that decision in particular as a judge.
Kim has her.
Quick question for each of you. So first, Mark, you've now made me realize I can't
write a single sentence about the Constitution without citing Jack. That's very helpful. But I'm wondering if you see, as to someone who just went through everything, and maybe, I don't know if Jack's the best commentator on this, do you see a downward spiral in his hope over time? He starts with redemption and ends with rotten crisis, right? So do you see a trend in all these concepts? The question, the question for John is, I love the pictures and I love the idea. And as you know, I adore your work on Jackson. What I'm wondering is whether American constitutional law would be better off if we didn't know all their names. In Germany, nobody knows the judges' names. And I guess I'm wondering whether the personalization itself is an issue we ought to think about. And that brings me to my critical comment on Rebecca's work, which I also love. And that is what you've pointed out is that maybe we're misguided in thinking there should be a national narrative of anything. So to what extent do you think your work on federalism suggests that actually any single national narrative is going to be wrongheaded? And so, because I think what's one of the lessons I draw from your, brave stuff on federalism. And then I guess my question for Sam is, one of the things I think, especially your last comment suggests, is that the most crucial thing, and that all of us working on constitutional design and so forth, who think we found the magic bullet, that what you're suggesting is the only thing that saves constitutional government is sort of play in the joints somewhere, or complexity of systems, almost no matter where it comes from. So it takes just longer to topple stuff. And I'm wondering if you think that's a friendly amendment to the idea of all the magic bullets that you were trying to suggest and then undermine.
Yes.
Other questions or this? Okay. We can answer your question. Two very brief thoughts. One, and that is, I think Jack says so, when you ride a bicycle, in one sense, there's a cycle turn, your foot winds up exactly where it was. But of course, the bicycle winds up in a different place. And so when we talk about cycles, we're not simply talking about, well, we've gone back to democracy, we're just like we were in 1866, that there is movement. Now, one of the interesting questions is in the global democratic cycle and in the American democratic cycle, each new democratic period has been more democratic than the democratic period before it. Will that be true? Or will, in an attempt to deal with the Trumps, the Orbans, and Netanyahus of the world, I suspect, for example, in Israel, the new democratic period will in fact be less democratic than the other one. The brief thing, in some ways, I'm fairly aligned with Sam outside of some vocabulary choices, because I think one of the things you can get from history is, how did they think the big C Constitution work? How did the Constitution actually work? What are the empirical things, their empirical assumptions, the empirical realities? And what we inevitably discover is, while there are some things we can take, their world is different than our world. Just one last thing, in the previous passage, we need to go back to legislative supremacy. We can never go back to legislative supremacy. We can say that the Constitution of the Civil War was designed to work with legislative supremacy, but there's no path back there. And so if we're simply saying we're going to imitate them, no, we're not.
In a world with John Harlan, Antonin Scalia, Sandra Day O'Connor as patron saints of various law schools, and a huge hunk of marble carved into John Marshall on the ground floor of the Supreme Court, we're never going to get to anonymity. I think it's a great question, and the European model has much to recommend it, but we are in a different approach. I've flirted with the idea, I've recommended this in front of a conference of judges, and it got a big gasp. Judges should not be promoted. If the phone rings and you happen to get a judicial appointment, great, and serve, and it'd be better if there was a time limit, but you might be, and I guess I'm talking federal courts, a district judge, a circuit judge, a Supreme Court justice, but no promotions. And then we would have no auditioning. And then we would take out of our current adjudication behaviors something that I think is really a cancer in the DC Circuit, in the Fifth Circuit, in different people whose names I won't recite, but you know what I'm talking about. You know, there are people who are anonymous in history, you know, who remembers Harold Burton, but he didn't write many opinions. He was a writer's block kind of justice. He was a hard-working kind of grinder and good voter as a Supreme Court justice. And he got that job because he sat in the US Senate next to a guy who became president of the United States accidentally. And he said, Harry, I would like to be a Supreme Court justice. And Truman said, sure. And, you know, that kind of random, one-time, no judicial experience service can be great. I'll take another Justice Kagan, who was never a lower court judge. I'll take another Robert Jackson, who was never a lower court judge. But, you know, like one stint in judicial service might sort of reduce the fever a bit.
I can't remember exactly how Sam put it, but I think it's something like, I'm at an academic conference and I'm going to go overboard. And I didn't mean to say that I always favor state authority, like I'm always in favor of federalism. In fact, what I really mean to say is that it's much more complicated. So, you know, having grown up, born in 1962, grown up with the Warren Court, being taught by professors who revered the Warren Court, the Congress, 1965 Civil Rights Act, the whole story we always heard was sort of, and when you're talking about civil rights and individual rights, federal power good, states bad. Right? You know, Cooper versus Aaron, et cetera. But it's more complicated than that. And so I actually think most people don't really believe in federalism. They just employ federalism to support the arguments that they want to make at the time. And so I guess what I'm suggesting now is and by the way, I had a great conversation with Tori, who I guess she's not here right now, at lunch about how federalism is not just federal and state, and the fascinating role that Indian tribes play in all of this too. So what I was just suggesting for today was that I think we need to, you know, it's good to remember, especially those of us of a certain generation, and now I'm older, right? I'm one of those older people, even though I still think of myself as a young whippersnapper, you know, that it's not always federal good and states not so good, that in fact, starting from the ground up is a good way to advocate for change. And it's also true, my mother just died in November. She was engaged in local politics her whole life. And so I think I've grown up seeing the value of local as well. After Obama was elected, I went to a conference. It was great. It was this big celebration. I know Jack was there because that's the first time I heard him mention that progressives should employ originalism. And Reva Siegel was there, and she was talking about we need a progressive vision of the Constitution. That's what we need. That's what we need right now. And she was absolutely right. But what I was focusing on at the time was that there was this really great candidate for mayor in Toledo that I was campaigning for. He had a very enlightened vision of what the city of Toledo could do. And I was right too.
Thank you so much to the panelists.